All right, so here we go again. David John Walter, Petition of Right, Prima Facie Evidence Forensic Document. We are up to page 71 till page 80. Okay, so here we're going to talk about the Majesty the Queen was to appoint a governor in Queensland, to the Ordering Council establishing a representative government in Queensland, 6 of June 1859 UK, unless personally requested by your subject in Queensland. So as we're reading in basically page 69, that the day after date, the petition of right, no governor personally sworn in appointed by your Majesty Queen holding the Orders Council establishing representative government in Queensland, 6th of June 1859. Okay, and now there comes the Legislative Assembly, so with no elected and sworn elected members of the Legislative Assembly, with the Queen sitting in the Legislative Assembly, there can be no judges of the Supreme Court of Queensland elected and appointed to fill the position required to administer the laws of justice as held to the Judiciary Act 40, Victoria number 6, and that's going to be the Judiciary Act 1903. Unable to impose any fine in a legal tender, pound, shilling, and pence, or imprison a person for criminal offence under the Criminal Code Act 1899. Important again. With no governor sworn and appointed by Your Majesty the Queen and holding the seals and authority of the Crown, no judge can be sworn in appointed to be given the seals of the Supreme Court Act 1867. 31, Victoria number 23, to impose any bigger fines or sentence or imprison any private person on the land of the Crown and holding imperial measurements, right? Imperial measurements, so it should hold in imperial measurements and not metric measurements. Crown and pay that consolidated revenue fund in pound sterling and pence, and hold to the Ordering Council empowering the Governor of Queensland to make law and provide the administration of justice in the said colony. For a very minimum for 23 years, there has been no judge in any Supreme Court of Queensland being elected by the members of Legislative Assembly, with the Queen in the Legislative Assembly sworn by the Governor holding the full and total authority of Your Majesty the Queen, the current holder of the Constitution Act 1867, as hold to the Common Law of England, holding delegation of separation of powers between Church and State. Great High Court case for the separation of powers is Arvid Kirby ex parte, a Boilermaker case back in 1956, High Court case, when they clearly stated that statutory body cannot actually impose or cancel license or cancel your registration without a court order. Now that was back in 1956. Just remember, as of 1966, we do not have the lawful government and lawful judges, lawful magistrates. Now, so then David John Walter goes back to the basically the 8 points, which what we would like. So reinstate the Commonwealth of Australia Constitution Act 1900, reinstate to have the letters patent. Petition to my personally sworn and appoint the governor hold the letters patent. So we want legitimate governors, and we want the letters patent, yeah, to allow the representative. When the Australian government commenced trading on 14 of February 1966, consists only member of registered political parties inside the deeds of the private constitution of the registered political parties, and hold to the memorandum of understanding, aims and object, the philosophy and policies of the members of the political parties, holding the delegation authority on individuals members only. Now, in delegation authority, under the Federal Crowns Act 1914, Section 3 ZZIA, you can always ask for delegation authority. There is no delegation authority as of 1966 anyway. They cannot provide it to you. So you can ask, but yeah, they're not going to be able to provide it because they just private corporations. They're operating under the private seal. They got their private laws, and etc., etc. So the public seal of 2001 is affixed on the face of Australia Citizenship Act 1948. The privately elected Chief Executive Officer of the Australian Government, Scott Morrison MP, Prime Minister. So that was back in 2 years ago when David John Walter wrote this petition of right, and right now is Anthony Albanese. The Parliament of Australia, unicameral parliaments, a single legislature which only consists of members of the elected members of the registered political parties inside the deeds, the private constitution of the political parties in Australia and states of Australia and territories of Australia, which also includes members of the Legislative Assembly of the Australian Capital Territory and Northern Territory, private single legislative only. I'm not a member of any political party. I'm holding of the private corporation law of the political parties of Australia operating on the land of the Crown and hold to the common law of England as every other person on the land of the Crown holder in the imperial laws of the Crown. There is no exception. Okay, so there you go. Imperial law, yeah, and under the Crown. Now, so there is the Petition of Right, okay, Magna Carta. So there you go. A Petition of Right 1627, okay, that's still valid, okay, back in 11 of July 2002, authorized by the Parliamentary Council. Then you got the Magna Carta, yeah, in 1297. Republic date 5th of July 2002, authorized by the Parliamentary Council. Act Settlement Act 1712 and 13 Bill 3. Republic date 5th of July 2002, authorized by the Parliamentary Council. Anglican Church of Australia Act 1902, reprogation 5th of July 2000, authorized by the Parliament Council, Australian Capital Territory. Okay, so this is basically, it's all valid. Settlement Act, so the Bill of Rights is still valid under the Settlement Act 1700. The Petition of Right is valid. The Magna Carta 1297 is valid. So you can have a look. If you don't agree with that, please do your more research. You can ask these so-called corporations, de facto Australian government, and you can always do FOIs, Freedom of Information request, and get more information. There has never been any referendum requested or sorted requested to alter or change the legal tender, there you go, of the Commonwealth of Australia. Sold to the Companies Coinage Act 1909. The legal tender of company pounds is the only currency of the company. It remains in place to this day. And when we're paying, it should go to the Consolidated Revenue Fund, but it's not going there because it's going to a private corporation. So anything we pay in Australian decimal currency, it does not stay with the people. Now, David John Walter lives in Queensland. Land is held inside the Constitution Act 1867 and held personally by Your Majesty the Queen right now by the King, the current holder of the Constitution Act 1867, Queensland. The currency of Queensland is legal tender of the company, pound, shilling, and pound sterling. Okay, so this is what people actually need to comprehend. Now, Your Majesty is not a registered member of the political party found in England, Scotland or Wales or in the European Union, and you do not hold any signed, sealed and dated civil partnership agreement in de facto relationship with the elected members of the registered political parties in the unicameral Parliament of the European Union. Prime Minister Boris Johnson, MP, is inside the European Union and holds signed person-to-person contracts in de facto relationships and holding contract under public seal of the European Union with the other elected representative of the European Union, who conducts all finance and trade in British pounds in electronic currency only by way of Electronic Communication Act 2000, Chapter 7 of Elizabeth II. So the legal tender of the Crown of the business dealing is pound, shilling and pence or pounds sterling for all commerce and trade, Great Britain, Northern Ireland, known as pound sterling. Okay, so all legal tender, and it should go to the Consolidated Revenue. The civil laws of all political parties, which include civil and criminal law, cannot be executed over Your Majesty the Queen, the current holder of the Companies Act 1948. And defender of face or any person living or working on the land of Your Majesty the Queen, holding the land in imperial measurements and legal tender England, pound sterling used for all commerce and trade. So the civil laws, private laws, statutory laws, whatever you want to call it. The laws is the common law of England, as hold to the laws given God to Moses for all people or nation, uphold the 10 Commandments. As the supreme governor of the Church of England, you personally must uphold the laws of God as the defender of the faith. I also presented matters to what I believe, this is David John Walter who actually presented matters, to private counsel with the Queen in council, and I refer to attached exhibit place petition to Chief Justice Kiffel, list of court cases for the pending matters. Those matters were refused to file under statutory law of Parliament of United Kingdom, which is a private business inside the European Union consisting members of registered political parties, trading in real and personal property only. So there is Lindsay Jackie. Okay, so that was in UK. Your documents have been received. However, they cannot accept it because the Judicial Committee no longer hears appeals from Australia. Under Practice Direction 725, the documents are no property of the Judicial Committee and cannot be returned. So that was from UK, Privy Council, right? Now, so there is the Judicial Committee Act 1823, Chapter 41.3 and 4 Bill 4 is currently held under seal of Your Majesty the Queen. the current holder of the crown and defender of the faith. The register into Jackie, a political appointed civil servant who refused to file documents, in fact keep document, and they become a property of the Judicial Committee of the Parliament of United Kingdom. Okay, so it's sitting there, and they didn't return it, they kept it. So obviously they know it's a very, very important document, and that was back in 27th of January 2011. Okay, so very interesting, and this is up to page 80. I will be back further ahead